Ms. Guerrero.
Good afternoon, Your Honor. I did meet with the client, and I wanted to kind of explain some of the factors.
Right away, Judge Boyd sets the tone. No small talk, no patience, you can almost feel he's bracing for excuses. What do you think? Do judges already know who's about to test their limits?
All right. So first off, is she allowed to drive or is she not allowed to drive?
She is allowed to drive. She does have a valid driver's license. Additionally, she does have the portable device, and she's blowing in that device 3 times a day.
Why isn't she on the ignition interlock?
That I don't have information for. I just know that she has the portable device, and that's what she was ordered.
All right. Ms. Smith, you're going to be placed on ignition interlock. You cannot be driving a vehicle and you're not on ignition interlock. I don't know why somebody would give you portable if you're driving.
Yes,
so just give me one moment. All right, Ms. Guerrero.
Yes, Your Honor.
I have something from August 23rd. Was something ordered after August 23rd? Because on the August 23rd, it says there's to be ignition interlock.
Quick breakdown, an ignition interlock is basically a car breathalyzer. If Hannah didn't have one installed, but still drove, that's a direct bond violation. No gray area here.
Don't have that information. She had Miss Corley, I believe, before. I don't know if Miss Corley did some type of amending of bond conditions.
All right, just one moment. To the clerks, could you keep looking through to see if there's anything else on Miss Hannah Smith? Just give us a moment, Miss Guerrero. They're going to look for it.
Thank you, Your Honor.
All right, Anton Hayek.
Still trap.
And let the deputy, thank you. All right, Miss Guerrero on Hannah Smith.
10-point trap.
Yes, Your Honor.
All right. This is what the court has discovered from reviewing the filings. Yes, a motion was filed where this defendant was allowed to have the remote in-home monitor installed in the ignition interlock with an affidavit of non-driving. So she's not supposed to be driving because she's using it in-home. So what she has done is she's violated her conditions of bond. So she's driving, and she's supposed to have, she's not supposed to be driving.
There it is, the bond violation confirmed. The rule was simple, don't drive. Yet here she is, caught behind the wheel. This isn't bending the rules, it's breaking them in broad daylight.
Okay. As far as I understand, I asked her about having a valid driver's license. I didn't ask her about the difference between the ignition interlock and the home handheld device. I'm sure that she would be more than amenable to have that ignition interlock placed on her vehicle. I do understand that there was an accident and her vehicle was not working, but maybe she has a new vehicle. I didn't get all those details, Your Honor.
All right, so that's what the court has, and that was dated on September 8, 2020. And the court doesn't have an order that's saying that she's going to be driving with ignition interlock. In my understanding, she doesn't have ignition interlock on her vehicle, and she should.
Okay.
So she's going to be going into custody today.
Boom, no bond, straight into custody. Now here's the question, is that justice served, or do you think the judge went too far? Drop your take below.
She violated her conditions of bond. I can't have someone. And Ms. Smith, I don't take it as true that you committed an intoxication manslaughter, but you're charged with intoxication manslaughter. And one of your conditions was, because your previous attorney came to me and informed me that you would not be driving. And so I allowed you to have the in-home monitoring device installed in lieu of ignition interlock if an affidavit of non-driving was provided. So you're driving and you don't have an ignition interlock. That's a problem. So you're going to be taken into custody today. Ms. Guerrero, she'll be remanded without bond. If you want to file a motion to have the court reconsider that or bring some more information to me, Ms. Guerrero, of course, the court will be more than willing to consider that. But for now, she is, I'm issuing a judge's warrant and she's going to be remanded.
Okay. I'll visit with her tomorrow through the jail and I'll report back. Thank you, Judge.
All right, thank you.
May I be excused?
You may be excused. So we're clear, some things happened. I think I remember this. Ms. Smith was not supposed to be driving. Ms. Smith, I believe, was behaving inappropriately and was asked to come to court. The court had no idea that Ms. Smith had been driving for who knows how long. And Ms. Smith drove to court, but she was in a vehicle on Zoom, and then she drove to court. So that's where we are. So Ms. Herrera?
And on that day that she came to court, apparently her retained attorney withdrew, and then I was appointed to represent her.
Yes.
So I haven't had this case very long. However, the court remanded her without bond on that day, and she's been in custody since. Her family is extremely supportive. They sold her vehicle so she wouldn't have a car anymore. Her employers contacted me, her boyfriend's contacted me, civic leaders have contacted me, her mother has contacted me. They all want her to get back out so that she can go back to work and show the court what she's done. She's been in 12-step programs. She has not had any positive UAs. She tells me that, she's been doing everything that the court has asked her to do, and that she was unaware that Ms. Corley had filed an affidavit of non-driving. She had been blowing into an in-home device, and she would like very much to be placed with a bond so that her family can make her bond. That if she has a vehicle, that she will put ignition interlock in there. But as of right now, her mother has told me they have sold the vehicle and they no longer have anything for her to drive. Her bond was set at $50,000 in inception.
Interesting, isn't it? Suddenly the car is gone, but only after she's caught. Accountability seems to show up late, usually when freedom's on the line.
Well, even though Ms. Corley did an affidavit of non-driving, people in this court who are on DWI, I always let them know and have them present when someone is doing an affidavit of non-driving, because I tell everyone that they need ignition interlock, and they say, oh, they're not driving, and I say, well, they need to provide an affidavit of non-driving. My concern is, she filed an affidavit of non-driving. Obviously, her signature is on it because it's an affidavit of non-driving, and yet she drove to court and she didn't have ignition interlock.
Judge, if I may, obviously, Judge, I was going to bring up my recollection of that day was the same as yours. I did want you to take judicial notice because I know you were on the Zoom that day. If there is an affidavit of non-driving on file, I presume that she signed it and that she was aware that she wasn't supposed to be driving. Regarding the indictment in this case, it's a very serious charge, among the most serious charges you can get involving a vehicle, and that's why we believe it's important, Judge, to not take it lightly, the fact that she said she wasn't driving and then she was for sure driving that day that we see her on Zoom driving. We can presume that she was driving on other days if she thought she was just free to drive. The state would ask for her bond, if you grant her a bond, for it to be doubled to $100,000 along with full GPS house arrest.
I'm still trying to figure out why should I grant her a bond when and mind me, Ms. Smith, I don't take any of the facts of these cases true because I haven't heard any facts. But what I have is you're charged with intoxication manslaughter. You did an affidavit saying that you would not be driving, and yet you were driving, which means you were driving without an ignition interlock, and you're charged with intoxication manslaughter. The number one rule when you have any intoxication offense, if you're doing an affidavit of non-driving, you don't drive. If you're driving, you have to have you have to have ignition interlock.
And that seals it, no second chances. From the court's view, if you can't follow the simplest order, how can anyone trust you with freedom?
So I'm not going to reinstate the bond. You're remanded without bond.
I'm sorry, I forgot that I had signed the paper and wasn't driving for that long. I'm really sorry. I have been doing so good, and I want to continue to do good.
But you knew you were driving without ignition interlock. But if you want to give testimony, I will swear you in. You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You can lower your hand, state your name for the record.
Hannah Marie Smith.
All right, Ms. Farrell, do you want to do question and answer, or you just want her to state?
I just want her to talk.
All right.
I did not, I was not aware. I do remember signing the paper, but I was not aware that I was not supposed to be driving at all. I did tell Miss Linda Corley, I called and I had spoke to Roland, and I had told Roland, he didn't tell me anything about getting the interlock or calling pre-trial. There's something about I was supposed to have called pre-trial. I was never told any of that. I would have done it. I have done everything that I have been told to do. I would have done it. I'm in IOP, I'm in precision recovery. I went to an inpatient program. I have a sponsor. I work the 12-step program. I go to AA meetings. I go to see Rick Green regularly Tuesday and Thursday night. I fully participate. I'm on back on my mental health medication. Being in the IOP program has put me, I have found out that I have hyperthyroid and Graves' disease, which I wasn't aware of until I had gone into the IOP program. Mentally and physically, everything about me has gotten so much better. This past year to year and a half, I'm really sorry. The car is gone. You can take my license. You can revoke my license. You can do whatever. I'm not gonna drive anymore. I take the bus.
Shut up. Shut up.
I'm trying. I tried really hard for a whole year. I'm sorry.
Any questions?
Nothing specific, Judge. I would just like the court to be aware, or just obviously, Judge, I mean, I think it's concerning that she's signing things, and the biggest concern we have whenever someone commits a crime with their vehicle is they're going to do it again, and she's not even aware of conditions that are part of her probation, or I'm sorry, part of her pretrial.
All right, and the court notes that there is a previous pretrial violation, Ms. Terrell, for hijack reading, but at that time, the court did not issue a judge's warrant or remand her without bond. But you knew you were not supposed to be driving, and yet you did it anyway. And you drove without ignition interlock. And again, we go back to the fact, I don't take it as true, but you're charged with intoxication manslaughter. So the motion to reinstate the bond has been denied.
Will the court consider any bond?
Not at this time. If you want to speak with the state and see if the state would be in agreement for a bond, but at this time, no. Ms. Ferguson, this is, the setting date on this is May 16th. Ms.
Correct, it's
Ferrell.
next week.
Okay.
May I be excused?
Yes.
Did she have a seat over there?
Yes.